Hi, Anita. How are you?
Hi Maya, I'm good, thanks. How are you?
I'm fine, thank you. So I'm excited here today because we're working on something new,
Yeah,
new idea, which is going to be very helpful for a lot of practicing criminal lawyers, especially because we are going to be working on this series that will guide people who are dealing with clients who will be going to the ORB or the Ontario Review Board. So just I'll give a very brief explanation of where this is heading. So this is really to explain, it's meant to be a guide for lawyers who have their clients who were found NCR and who will now have to deal with the ORB, knowing that the ORB is a completely different world with its own way of functioning. We're not dealing with criminal courts, we're dealing with the review board. And knowing that things are very different and that sometimes it's difficult to find information about that, we would like to guide everyone here. And hopefully, these series will be helpful and will be of assistance to many lawyers who find themselves in this situation and they don't know how to deal with these types of situations. So, we're going to start from the beginning when the client is found in a criminal court to be NCR. So the big question is, Anita, now what? What happens to the client and to the lawyer?
sure. So I hear from criminal defense lawyers often with alarm and concern about what's happening with their NCR clients. And the point at which I hear the most often from them is after an initial hearing of the review board, when the lawyer is shocked and appalled to find out that their client is going to be detained in the hospital when it's clear that the lawyer, sorry, that's my alarm to make this video, when the lawyer was sure that his client would be released or would remain in the community if they were out on bail after a finding of, um, well,
NCR finding.
after the NCR finding the bail conditions. We should just flag that. Any pre-existing bail conditions that were in place generally remain in force until there is a first disposition rendered by the review board. But so when I hear with alarm from defense lawyers is when A, they were certain that their client would either be released or would stay in the community after the review board receives them and renders a disposition. And because of that firmly held belief, which they passed on to their client, they have a very angry and very justifiably upset client who has suddenly lost their liberty and is effectively incarcerated, except in a hospital setting. So I want to back up for a little bit, go back to your original question. Let's go back to the moment that an NCR verdict is rendered by a trial judge or a sentencing judge. So there's the NCR verdict. Your client's been found not criminally responsible. Many criminal defense lawyers presume that this now ends the role of the criminal court in the client's progression through criminal justice, and that next they will automatically or necessarily be remanded into the jurisdiction of a criminal code review board. In Ontario, the Ontario Review Board. So it's important to recognize that that is not necessarily the case at all. There's a very important step that can be invoked in the courtroom immediately on the heels of an NCR verdict. You can, as a defense counsel, invite the court to make the initial disposition with respect to your client right there in the courtroom. So under Part 20.1 of the Criminal Code, NCR accused, when they get a disposition order, most often from the review board, when they're first presented under the jurisdiction of the review board, they will get a disposition ordered by the board. And we'll talk about this later as we go through the law in another session. But the disposition options under 672.54 of the Criminal Code are number one, an absolute discharge, number two, a conditional discharge, or number three, a hospital detention order. So there's this belief that when your client is NCR, as soon as they're found NCR, they'll go off to the hospital and be detained, as Part C of 672.54 would allow a disposition to be made as a detention order. Not the case at all. You can ask your trial judge to please make the first disposition order, to make a disposition order under Part 20.1 under 672.54 of the Criminal Code right then and there in the courtroom. And every disposition option is available to the court. And we've gone over the three disposition options. So an absolute discharge is an available disposition option for your trial judge. In other words, you can be found NCR, at 10 a.m. and at 10:05 a.m. you may be absolutely discharged altogether, in which case your criminal record, your NCR verdict, everything has evaporated. You walk out the door completely free with no record, and the NCR is wiped. That can take 5 minutes. How often does that happen? It's not routine, it's not a regular occurrence, but it actually happens more often than you think. So I believe I read some studies that say 10% of those found NCR may find themselves absolutely discharged in that courtroom. Now,
Mhm.
when would that happen? Like, what are some ideal facts for such an absolute discharge immediately on the heels of an NCR finding? Obviously, we're not talking about a homicide. We're not talking about a serious sexual assault that's recent offending. We are talking about one of two things. It may be a marginally more serious offense that perhaps happened some number of years ago. So there are certainly cases that progress through the courts where the period of time between a finding of guilt and NCR verdict is like 4 years or 5 years. So for whatever reason, things occasionally happen where it takes a very long time for the NCR verdict to be rendered, or for the NCR hearing for that matter to be heard. Those are often more serious cases where a number of experts perhaps are retained by both the defense and the Crown. And it just takes a really long time for those expert reports to come in, for competing experts, to be privately retained, for the hearings of the evidence of the experts, and then for judges to make complex decisions. So even in a somewhat more serious case of offending with perhaps even some violence, if you've had someone out on bail, never breaching their conditions or their terms, doing really well, reintegrated to the community, they have a job, they're on their meds, everything's fine. There's a chance of seeing an absolute discharge right after the NCR. There's an even better chance of seeing a conditional discharge right after the NCR. Now, the problem with a conditional discharge as opposed to an absolute discharge is it's not as good, because even if the court makes a disposition right off the bat, once there's a disposition made other than an absolute discharge, which is the end of the story, obviously, in criminal justice for your client. But if a disposition is made other than an absolute discharge, whether it's a discharge on terms and conditions or a detention order, that judge's disposition must be then reviewed very quickly by the review board. So it's within 45 days. The review board must meet and issue a disposition within 45 days if the court chooses not to make any disposition. So it's important to get an initial disposition quickly. But if the court does make a disposition, then the review board has to review that disposition within 90 days. So if you're gonna advocate for your trial judge to make a disposition, you want to have a good shot and a good argument for an absolute discharge. So the highest likelihood of an absolute discharge in an NCR situation is an individual with a very low level of offending who clearly was not criminally responsible at the time, whether it's shoplifting or mischief or uttering threats. And for whatever reason, an NCR verdict is made because it's an appropriate NCR verdict. Someone was really not responsible for their actions. They really didn't appreciate what they were doing or the nature of their actions. And it would be unfair to hold them criminally responsible, to saddle them with a criminal record. Maybe they have no pre-existing criminal record. The NCR verdict means they still don't have a criminal record, so some people want an NCR verdict for that reason. Um, but the level of offending is just so laughably low that an absolute discharge also seems like an appropriate disposition that the court is comfortable making. So you can invite your child just to do that. It's up to them. They can choose to go ahead and make the disposition, or they might say, as is most often the case, that they're not comfortable, they're not familiar enough with the law,
And
and they
they'd
would
rather
prefer to
transfer to the ORB.
again to the review board. Yeah.
But I do have a question here, Anita. Is it advisable to have it transferred to the ORB, or or it seems from what you're saying that if it's a really very low level type of crime, that it doesn't really make a difference if it's the trial judge, because if there seems to be a very strong chances that an absolute discharge is warranted, then we should just go ahead and ask for the trial judge, because then it will really end everything right away, right? Because if it,
Yeah. Yeah. So the chances of a liberal disposition that protects your client's liberty and freedom, like an absolute discharge, are very much higher coming from the trial judge than they are from the review board. So
mm-hmm,
the review board doesn't care how low level the offending is.
mm-hmm,
They're going to continue to detain your client from the beginning right through the bitter end, depending on other factors. So the important the important disconnect that most legal practitioners do not understand is the NCR verdict. It makes no determination, contains no implication, and has not considered the issue of significant threat. So just because your client is found NCR, nobody has done a risk assessment for that client. There's nothing inherent in the NCR verdict that says your client is dangerous. It only means that in the moment of offending,
mm-hmm,
they did not understand the nature or consequences of their actions, or that they were wrong due to mental disorder. That's all it means. Doesn't mean they're dangerous. Once they come under the review board's jurisdiction, in order to keep them under the criminal law, the first threshold issue is whether or not they pose a significant threat to the public safety. The difficulty is at the initial hearing, review boards and other justice system participants often assume that because the NCR verdict is so recent, the significant threat threshold must be met. But nobody's looked at that threshold. So the first look at whether the client is dangerous or not comes at the review board if you
mm-hmm,
get that far. But if what you want to do is get a liberal disposition toward a discharge, conditional or absolute, the chances of a trial judge giving that type of disposition are much higher than the review board giving that type of disposition. So I would, I don't see many cases um, where it would not be of assistance to get the trial judge to give it your best shot in front of a trial judge to see if you can get some type of discharge. Obviously, on a recent violent offense or a serious offense, that's not going to fly. But if you're dealing with a lot of the run-of-the-mill things, there is no downside to asking your judge to make that disposition. That judge is not going to make a more restrictive disposition than the review board might. And if they do, it will be corrected within a number of weeks, within 90 days when it's reviewed by the review board. So if your trial judge does something unexpectedly terrible, it's guaranteed to be reviewed by the review board. But otherwise, there's no downside. Though you can ask, and the worst thing that'll happen is the judge will say, "I'm not comfortable dealing with this. You're going over to the reviewer." So I don't know why. The only thing I can think of is that most people are not aware that they could try and get the trial judge to make this decision. And if you know enough about the law and you know enough about the practice in this area, then you can persuade your trial judge to make the decision. You can empower your trial judge by giving them the tools and explain to them why they should be comfortable, why it is safe for them to make this decision. They're familiar with the offending, they've received expert reports. Those expert reports contain at least some information about the history and background of the accused. And ultimately, the legal disposition that's to be made that impacts your client's liberty is a legal disposition. Ultimately, the board renders a legal disposition too. It's not really a psychiatric determination. even though the review board has some psychiatric expertise, that psychiatric expertise within the review board generally does not help your client. It's generally going to overestimate dangerousness and be risk averse and overly cautious about releasing your client. So my advice is ask your trial judge, say we'd invite the court to make this initial disposition. What's the worst thing that can happen? They'll say no.
All right. And then if there is something that goes wrong, like you said, there are chances that it will be corrected later on by the Ontario Review
Well, it'll
Board.
be reviewed. Whether it'll be
Yeah.
corrected or not, I don't
Yeah.
know. At least it'll be reviewed. Yeah.
All right. So, um,
Yes.
then what's the next step that lawyers should be aware of?
Right. So, well, I think the fun starts here. So, I actually am not normally on the receiving end of the court documentation. That's the Crown's office. And someone like Michael Findell, who's our lead Crown in Ontario and down at CAMH, certainly does a lot of the ORBs. He would know better, but the paperwork is a bit of a mystery to me. They have the Crown codes new accused information sheets. So someone comes into the system as a new NCR accused. They get this file. There's a particular kind of form that is flagged as the new NCR accused information sheet. And then all of the paperwork from the trial, the reasons for the NCR verdict, often together with the various psychiatric expert reports regarding NCR. Maybe if there was a history of unfitness before the NCR, there may be fitness reports. Some portions of a trial transcript, depending, a CPIC, information, whatever is in the court file goes off to the review board. Um, and at some point, the review board will send an email, usually to the trial lawyer, the defense lawyer who was on record of the trial, saying, we've received information that your client is now NCR, and the board is going to be convening an initial hearing. So the problem is, as I've said, the criminal code mandates an initial review within 45 days in the event the court did not make an initial disposition, which is almost always. And almost invariably, this is never going to happen. So I don't know that I've ever seen the review board discharge their duty to convene within 45 days. It's simply not going to happen. Why not? That's a good question. Instead, what will happen is the board will say, this is a new accused. So the board proposes to hold a pre-hearing conference to
Mhm.
see what the next steps are. And I think the review board considers that it has convened the hearing within the 45 days when they have a pre-hearing conference about it. Of course, that's not our view. So, from the defense perspective, we don't agree that a telephone call with the parties to see how things are going is discharging
Constitutes, yeah.
the hearing because no order is being made. And so, another big problem is that there are no beds at the inn. So at the moment, psychiatric hospitals are chock full of NCR accused, and there really are no beds. So what should be happening is if the court has remanded your client to the jurisdiction of the review board, they will generally, if it's anticipated that the accused will be going to a hospital, or if they first of all, they might already be in the hospital. They may
Mhm.
be within the hospital because they were assessed with respect to criminal responsibility in the hospital when that report was tendered to the court and they were found NCR. In that case, they're likely to stay at that hospital and the initial hearing will be held at that hospital. So what's weird is our clients randomly get stuck at weird hospitals that are nowhere near where they live if they offended in a different area or if the bed registries for the assessments only had assessment beds available out of town. So you might have someone from Ottawa who ends up assessed in North Bay, and I've had this happen to a client who offended in Ottawa. They were assessed for their criminal responsibility in North Bay Psychiatric Hospital because that was the only place that had a forensic assessment bed available. And then that person ends up having their first hearing before the review board in North Bay, and they end up detained in North Bay. And in my client's case, she's been there for 3 or 4 years, and we only just got her transferred out of there and actually over to Toronto at the last hearing. So weird things happen depending on where bed availability is. But if someone's still in jail at the time that they are referred over to the review board, at least in theory, there would be an order that they be transferred to the hospital pending their initial hearing. But the hospital will simply, if there's one of these pre-hearing conferences, the hospital will simply indicate that they don't have any beds and nobody will have any clue. There'll be a series of pre-hearing conferences. Well, when is my client going to be transferred from jail to the hospital? Everybody will say they have no idea. And then everyone just sits around going like, let's hold another pre-hearing conference in 2 weeks and see whether Mr. So-and-so has been transferred into hospital. So that is not how it's supposed to happen. This is a combination of bed shortages at the moment. The whole system is completely um, backlogged, and there's a funnel effect, and people are waiting months and months to get into the hospital. But that's what's supposed to happen. There's two other things I want to mention. I think we can probably stop there for this segment, but um, so it is also possible that you have an accused person already living in the community on their
Mhm.
bail conditions.
Yeah.
That will just they will stay out of custody until and unless the review board meets and renders a disposition. That's a detention disposition. The other thing that will happen often, at least here in Toronto. And again, there's jurisdictional differences in terms of locally, we have 11 forensic psychiatric hospitals across Ontario. One is a youth facility, SELAPS, but 10 are for adults. So there are regional differences as to how different hospitals proceed. But at least in Toronto, when there's an initial hearing that's coming up, and in some cases, the NCR assessment is quite dated for whatever reason. But even if it isn't, the NCR assessment, as I've said, is not a risk assessment. It relates to the moment of offending. So at these pre-hearing conferences, what happens, at least here at CAMH, is the hospital's lawyer will say, the chair of the pre-hearing conference will say, well, what disposition is the hospital going to recommend? What are they recommending? Detention order, discharge, absence? And the hospital's lawyer will say, well, we have no idea because we don't know this person, that he wasn't assessed at our hospital, or even if he was for criminal responsibility, we need to do a risk assessment, and he's not our patient in that he's not under the review board as yet, so he's not a patient of the forensic service because he's not had a disposition. So they will ask the board to make an order to one of their psychiatrists to do a risk assessment to enable them to give a recommendation to the board initially. My own view is this is a weird sort of money-making scheme because the order comes with money to pay someone to do an assessment. And these assessments often don't help your client because they'll only go so far as to assess their mental state for dangerousness, and they might make a recommendation that he should be detained. But especially, and this is a big pet peeve of mine, if they're living in the community, the assessing psychiatrist will say, well, I think they should be on a detention order instead of a discharge. And we'll say, well, why? They've been in the community for 5 years. And they'll say, because we haven't had the opportunity to assess their home as suitable for them to continue to live in. And then perhaps, as you would say, Maya, or any common sense person might say, why don't you go look at it? And they'll say, that's not part of the purview of my assessment order. So they're being paid to talk to the person, find out if they're dangerous. So they'll have the person come in for 2 hours to talk to them or review the paperwork. But I guess there's no additional stipend or something for them to. So they'd rather detain a person or have a detention order because they say we don't have information or enough information about the suitable nature of their living environment. And so that's always going to be the initial disposition order. If this is allowed to unfold this way, is always going to be a detention order unless you start to fight about that. And I've been fighting this a lot. So I've been bringing all kinds of evidence, the mother they live with, other people's evidence to say, look, they've been out there this amount of time, they're perfectly safe. Here's the mother, they'll bring him in to meet. But it gets very complicated, the initial hearing. So I think for purposes of this session, Maya, the point I want to make, there's a few points. One, don't dabble in this area. It's very complicated. So if you're going to follow your criminal client after trial, don't let it be a one-off because you either roll up your sleeves and learn this area, or in either event, you want to be very prepared because it is an absolute epidemic that a criminal lawyer comes off a trial, there's an NCR client, they go to the hearing, and their client lands in hospital for the next 5 years, and they're calling around saying, how could they do this? He was out on bail. Well, they can do it. They will do it. And if you would like to make sure that that doesn't happen, then you need to read the law. You need to read their records. You need to understand what you're doing. You need to understand the forum. You have to understand the local practices that are particular to your jurisdiction. And it's a lot to learn. So we're here to help you to learn it if you want to learn it.
Exactly.
But you have to do the work. You have to want to do a good job because your client's liberty is massively at stake. So you want to be careful.
And we will talk in future episodes as well about their rights and liberties and charter issues as well. So this is to be continued. So thank you, Anita, for this first episode.
My pleasure. Thank you, Maya.